Under Section 48 of the Indian Patents Act, a successful applicant is granted 20 years of exclusive rights to make, use, and sell their invention. It is an absolute, state-enforced commercial monopoly. This monopoly is governed by the Patents Act of 1970, operating within the boundaries of international treaties like the TRIPS Agreement. But as this lifecycle flowchart shows, India does not operate a simple registry where you file paperwork and receive a certificate. The system forces every invention through a rigorous, multi-stage statutory gauntlet. The Act creates an intentional friction. It offers robust protection to the inventor, but arms the state and the public with aggressive legal mechanisms to revoke that protection the moment public interest is compromised. An abstract idea only converts into an enforceable property right if it can survive every procedural trap, technical test, and strict timeline built into this legal machine. The baseline criteria for patentability are universal. The invention must be novel, it must be capable of industrial application, and it must contain an inventive step. To prove an inventive step exists, Indian courts rely on a 5-step cascade, the Bishwanath-Prasad test. Step 1 identifies the baseline knowledge of a competent engineer. By the 5th step, the applicant must prove the leap from prior art wasn't obvious, ruling out hindsight. Yet passing this judicial test is not enough. The invention immediately hits the negative list under Section 3 of the Act, which explicitly defines what absolutely cannot be patented in India. This list strips away broad categories of innovation. Section 3K outright rejects mathematical methods and software algorithms per se. Section 3P acts as a shield against biopiracy, blocking the patenting of traditional knowledge, like formulations rooted in Ayurveda. For the pharmaceutical industry, Section 3D acts as a strict barrier. You cannot patent a new form of a known substance, like a minor molecular tweak, unless you can prove it results in significantly enhanced efficacy. Section 3 actively shifts the burden onto the applicant. It forces them to mathematically and scientifically prove their work is a true technical advance, rather than a superficial upgrade extending an expiring monopoly. Once the subject matter qualifies, the procedural clock starts. Securing international protection generates an immense administrative burden, and timing is heavily regulated. An applicant chooses between 2 routes, a 12-month convention application or a 31-month PCT window. But early public exposure creates the threat of anticipation. If published before the priority filing date, the application is immediately rendered invalid. The Act only provides very narrow safe harbors against anticipation, such as demonstrating the invention at a government-notified exhibition or conducting a public working strictly for reasonable trial purposes. During this waiting period, applicants must navigate a unique statutory tripwire, Section 8, demanding continuous disclosure of all foreign patent applications. Failing to update the Patent Office about foreign filings via Form 3 within the prescribed months, that omission alone provides direct legal grounds to revoke the patent entirely. The system is unforgiving. A minor administrative failure to submit paperwork is treated with the same severity as lacking scientific novelty. Applications sitting in the Indian Patent Office are not examined automatically. To trigger an evaluation, the applicant must explicitly file a request for examination with 31 months, or the application is abandoned. This generates the first examination report. The applicant then enters a technical negotiation, amending claims and arguing against objections to prove compliance. If objections are resolved, Section 25 crowdsources patent policing through a dual pincer opposition system. First, pre-grant opposition allows literally any person to block the grant. Second, post-grant opposition gives interested parties a strict 12-month window to petition for revocation. Opponents can attack the patent on highly specific grounds, arguing the invention was wrongfully obtained, claiming it lacks an inventive step, or proving it falls under Section 3 exclusions. This open-season framework intentionally places the burden of defense on the applicant. It ensures only rigorously drafted, scientifically valid inventions survive the scrutiny of well-funded competitors and public interest watchdogs. When an application finally clears these hurdles, the Section 48 exclusive rights begin. The inventor holds the monopoly. But Section 83 introduces a critical paradox. The law explicitly states that patents are not granted merely to allow the patentee to enjoy a monopoly for importing articles into India. Patentees face an ongoing obligation, routinely submitting Form 27 to prove they are commercially working the invention to an adequate extent inside the country. 3 years post-grant, if the patentee is caught hoarding the technology or failing to supply the market, a critical vulnerability opens up. As this loop illustrates, if the patented product isn't available at a reasonably affordable price, or if the demands of the public are simply not being met, Section 84 triggers a compulsory license. Under a compulsory license, the controller forcibly pierces the monopoly. They authorize a third party to manufacture and sell the product, directing them to pay a government-determined reasonable royalty to the original inventor. An Indian patent is never a passive asset. It is a conditional contract that requires continuous, measurable public benefit to justify its own existence. By design, the Indian patent framework carefully manages the friction between private reward and public access. It enforces strict filing procedures, survives adversarial oppositions, and respects a 3-year waiting period before issuing compulsory licenses. But the state retains an ultimate failsafe. Section 92 acts as an emergency trigger, allowing the central government to entirely bypass standard procedures. In cases of a declared national emergency, extreme urgency, or a widespread public health crisis, that 3-year protective window granted to the patentee vanishes instantly. The controller can completely waive the required hearings and opposition notices, authorizing immediate local manufacturing of the necessary technology or medicine to solve the crisis at the lowest possible price. Furthermore, under Section 100, the government holds the inherent right to directly use any patented invention for its own state purposes, regardless of whether the patentee consents. The statutory gauntlet operates exactly as intended. It forces inventors to prove the high technical merit of their work, while ensuring that a private monopoly is never allowed to eclipse the public's fundamental right to survive.